Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi semuanya, ladies and gentlemen. Good morning and welcome. And before we begin, I would like to ask for a moment of silence in honor to the memory of Afwan Kurniawan, the ojol driver who tragically lost his life due to police brutality during a demonstration yesterday evening. 1 minute of moment silence. Thank you. Good morning again. We are here today to discuss the evolving relationship between law and politics, a phenomenon often referred to as the judicialization of politics. This is a timely and critical conversation that speaks to the very heart of democratic governance. Today, courts are no longer passive arbiters. They are central political actors, shaping everything from policy to the distribution of power. This raises fundamental questions about judicial independence and the balance of power. We see vividly both in the United States and in Indonesia. This lecture is a collaborative effort between Indonesia Jentera School of Law, the University of Washington School of Law, and Universitas Indonesia. We are privileged to have a panel of distinguished scholars from each university, from University of Washington School of Law and Universitas Indonesia and Jentera, to guide our discussion. And first speaker is Professor Mireille Butler from the University of Washington School of Law, and Professor Elizabeth Porter, also from the University of Washington, and Choki Ramadan, lecturer at the Faculty of Law, Universitas Indonesia, and Bivitri Susanti, lecturer at the Indonesia Jentera School of Law. Thank you all for joining us, and I will hand it out for our speakers. So it will be Professor Butler and Professor Porter, a total for 30 minutes. Joki, it will be Mbak Bivitri as the final presenter.
Right. Hi, everyone, and thank you for being here today. We're going to talk a little bit about United States Constitution, some of the contemporary issues, and also touch on the evolving role of courts and especially of the Supreme Court here in the United States. So you know us, as we were kindly introduced. We both teach at the University of Washington School of Law. Professor Porter teaches as a torts professor. She's also a constitutional law specialist. I teach legal analysis and legal reasoning at the University of Washington. We wanted to start by just kind of setting up the ground rules a little bit.
Yeah, as many of you may know or may not know, in the United States, we have what's known as the doctrine of judicial review, which means that if something is a constitutional question and the answer depends upon the interpretation of the Constitution, the United States Supreme Court has the final word on that issue. And for example, neither Congress nor the president can. This principle of judicial review, which we take for granted, it's the air we breathe, is not actually written into the Constitution. It was a decision made by this man, Chief Justice John Marshall, who was the intellectual father of the Supreme Court and who used his time at the Supreme Court to write opinions that drastically increased the power of the Supreme Court. And what we want to talk about today is how, to some extent, Chief Justice John Roberts in today's Supreme Court is, in a slightly different way, accomplishing the same thing or seeking to accomplish the same thing by using judicial decisions to expand the power of the court in our modern governance.
And so I think that one of the things that we wanted to start out with is actually, and as we see this slide summarized what Professor Porter just talked to us about, the roadmap for today. Then Professor Porter, who actually is the architect of this presentation, I'm just her sidekick. Professor Porter actually separated the current issue that we have in three buckets. The first one, issues relating to separation of powers, which she will cover. The second one, current issues related to constitutional rights, especially some of what we call the individual rights under the 14th Amendment. And Professor Porter then will finish with current issues that relate to the Supreme Court procedure and also how this court is using procedure to advance some of its political agenda. Just very quickly, the report looks like right now. And some of the information that Professor Porter also wanted to pass on is that the Roberts Court actually decides fewer cases than all previous courts, but the types of cases that they are reviewing is different nowadays. When Justice Roberts joined the Supreme Court, the only Supreme Court justice who was there was Clarence Thomas. This court has completely changed, and its ideology has changed, and it's become much more.
Again, under Chief Justice Roberts, the Supreme Court has worked to do really more than three things, but three fundamental things. First, they've drastically increased the power of the president. And as you can see from watching the news, this has had far-reaching consequences into the lives of not only Americans, but people all over the world. Secondly, they work to really to contract the power of other parts of the government, particularly administrative agencies. And throughout this process, what have they also done? They have expanded their own power. There are only 9 justices on the Supreme Court, but they have in a way drawn power away from the executive branch, away from lower federal courts. So we have about 1,700 federal court judges all over the country, but the 9 Supreme Court justices have taken a disproportionate amount of power. Here's some examples. First, of expanding presidential power. In 2024, the court issued what I think is probably the worst decision, personally, that the court has decided under the tenure of Chief Justice John Roberts. In Trump versus United States, the Supreme Court held that presidents are immune from criminal prosecution for acts that they perform as president, if those acts are within the very outer possible perimeter of what could be an official act taken by the president. This, of course, matters because in 2020, outgoing President Trump made significant efforts to overturn the result of the election in which he lost and President Joe Biden won. And there was an attempt by the Department of Justice to prosecute him. In this decision, the Supreme Court also happened to mention that the Supreme Court, that the president has the sole power to issue pardons under the Constitution. So of course, when President Trump became president for a second time, he pardoned all of the people implicated in the efforts to overturn the election. And he could at any time preemptively pardon himself. So this theory of a strong, bold, fearless, unitary executive is in many ways out of touch with our understanding of the United States, and it gives the president a vastly expanded power, which our current president is using. Second, and this is in the news right now, the Supreme Court has allowed Donald Trump to fire members of executive agencies who are allegedly independent because they say basically he's the boss. So this also was a 2025 decision. This has disrupted long-standing a long-standing precedent and norms about the way the federal government operates. When the court decided this case, Trump versus Wilcox, again, just this year, the court specifically noted that the Federal Reserve Board, which controls interest rates and the economy, is perhaps a different type of agency where firing such an official would perhaps not be lawful. However, now President Trump has fired a member of the Federal Reserve Board. just in the past week or two, this is ongoing. This is Lisa Cook, and she is currently suing the Trump administration, arguing that her removal violates both the Federal Reserve Act statute and also her own due process rights. The president's argument for why it's acceptable to fire Lisa Cook is not related to her work on the Federal Reserve Board, even though he has strongly criticized her for voting to refuse to lower interest rates. Instead, he's accusing her of having falsified information on the mortgage application for her house. So you can see this is a very typical authoritarian playbook where there'll be pretextual inquiries about the minor details of people's lives. So he's saying that he's removing her for cause. It is actually unclear what Lisa Cook did on her mortgage application at this point, and unclear how courts will resolve this.
And in the complaint itself that you were taking a look at this morning, you can see that the complaint that Lisa Cook now has filed suing the administration, she actually cites as evidence a lot of Twitter type, Truth Social type feed that he has made, calling for the Federal Reserve Board to take action to lower interest rates, to do certain things, and that she refused to do. So we know it.
But despite the fact that it's a pretext, if it's found that she did falsify information on her mortgage application, it's not actually clear to me what will happen, because somebody who's in charge of the economy, which is a deep position of trust, may be held to a very high standard about things like mortgage applications. So the jury, we say this in our jury system, the jury is out. Relatedly, the president has also fired vast numbers of American employees for administrative agencies. And the Supreme Court has said that firing those long-time civil servants, many of whom are repositories of expertise in the nation, was lawful. And those people have, in fact, been removed from office, decimating federal agencies, which most Americans don't realize are actually incredibly important to their lived experience as Americans. Here's an example. He fired vast numbers of people who work for the National Park Service. National parks are an important part of Americans' vacation life, particularly in the summer. And national parks are especially important to people, frankly, who don't have very much money. They can drive to national parks and go camping. And this year, Americans all over the country are having a lot of trouble because there are no employees to help check them into campgrounds, to help clean up litter, to help guide them on park trails. So there's something of a crisis at our national parks this summer. Just one minor collateral effect of President Trump's decision to decimate the civil service.
So now that we have covered basically the expansion of the presidential power of the executive branch, we're going to go into a second issue that again is being just addressed through the Supreme Court, and where there's been a lot of changes in our society, and that really has to do with a lot of constitutional rights, especially individual rights under the 14th Amendment. So the court has has reduced certain constitutional rights. We're going to give you a sampling: rights of racial minorities, of women, LGBTQ, and there's still some issues that are related to immigration. So that are still in play today that we're going to talk about. So to kind of set the scene again, 14th Amendment of the United States Constitution, which really prevents discrimination by not just the federal government, that is solely encompassed in the 5th Amendment, but the 14th Amendment is broader. It also addresses state action, and it also, even though those rights are not written in the Constitution itself, the tradition at the Supreme Court has been to read the 14th Amendment as protecting certain types of individual rights, even though they're not explicitly stated there. So that's what we're looking at: due process and equal protection under the 14th Amendment. Well, starting in 2023, you had the decision in Students for Fair Admissions v. Harvard College. So you might be thinking, oh, I thought that you could not, basically the decision said, hey, Harvard, you cannot discriminate against white and Asian students. So therefore, affirmative action basically was no longer constitutional. You might be thinking, well, why would that be the case? Because Harvard is a private institution, but actually because Harvard receives government funding, it was equated to a state action. And so that's what happened there in that case.
And just to clarify, in our country, we have an incredibly long history of segregating schools according to race. So up and through the 1950s, it was perfectly normal. It was typical for Black students to have to go to a separate school from white students. And even after the Supreme Court ruled that unconstitutional in the 1950s, it's functionally still, that legacy is still with us today. So affirmative action is an effort to basically provide a remedy for that systematic discrimination, which gives some people a much less robust education than others. And now the Supreme Court is looking at it and treating everybody the same, basically disregarding that long and pernicious history.
And you can see that again in the text of what was held and in the justification, as Professor Porter indicated, equal protection should be colorblind. However, we are not living in a colorblind society, so that actually is very difficult to put in place. Following up on that kind of same theme, there was a much more recent decision, you might have heard about this, about the funding freezes. Now, this is affecting Harvard because Harvard actually fought back and decided to sue the administration, but it's affecting every institution. We had a talk last week at UNPAD where we actually did discuss what is happening in academia right now and the effect of the funding freezes on all of the institutions in the United States, including the University of Washington. What happened in, and I'm just going to summarize, those slides are compact, but just basically the Trump administration froze more than $2 billion in funding because it said that Harvard was actually enacting an anti-Semitic agenda. Now, again, to go back to the authoritarian playbook, what's quite interesting is that there's a lot of anti-Semitic people in the Trump administration itself. But somehow they are going after those higher education institutions, saying, hey, because of what happened in the demonstrations about Gaza, you were showing that you were anti-Semitic, so we're going to freeze funds, you need to follow.
In addition, I think taking down an institution like Harvard chills other institutions, right? If Harvard can get attacked and destroyed by the Trump administration, then other universities that have fewer resources will tend to fall in line. So there's another aspect of this somewhat authoritarian turn as well.
And so Harvard filed a lawsuit, which is great, right? Because there's been a lot of institutions, a lot of law firms that have caved and that have actually tried to settle with the Trump administration because they're fearful. They don't want to lose their funding. Harvard actually fought back, which sets a good example. And Harvard said, hey, you're really just trying, again, pretextual, you're really trying to prevent us from saying what we want to say. The judge, there was a recent hearing in Boston where the district court judge actually said, well, what's the relationship between research and anti-Semitism? But the government lawyer said, listen, this is not about, First Amendment. This is not about speech. This is not about any of those issues. This is just purely about our right to do a contract, have a contract. And if you're not following the terms of a contract, we rescind the contract. This is nothing to do with trying to leverage anything. Of course, that's a legal argument, the legal chicanery, but it really is not about what it's on. Another case that you likely are all very familiar with is the Dobbs case. And that was the case that basically decided that basically even though there was a precedent that had been well settled, Roe v. Wade, for a long time in the United States, that basically the court was going to say, hey, we decided this wrong. We kind of saw a right there in the 14th Amendment when it wasn't really there. So now we're leaving it to the states to enact what they see fit in terms of abortion. And if you take a look at this map, you will see it's a little bit difficult to read, but you would see that the red and orange are really the states where they're really limiting, either not allowing abortion at all or limiting abortion. And the blue ones are really the ones where there is some limit, but the limit is much greater and more similar to what used to happen before.
If you look where we live on the West Coast, you can see the red state, that's Idaho. And Idaho has a very, very harsh law that will punish physicians if they provide an abortion to a woman, even if her health is threatened. The only legal reason is if the woman's life is at imminent risk. And what that's meant in Idaho is that many physicians have stopped actually delivering babies because they're afraid that to allow someone, for example, to lose a kidney or become infertile as a result of complications of pregnancy would be both ethically troubling and perhaps medical malpractice. So many women in Idaho come to Washington for their obstructive care right across the border.
And that has created really surreal situations for doctors. I actually think that we as lawyers are in a hard time right now, but anyone who's a scientist, who is a doctor, actually must wrestle with those ethical really decisions. Do I save a life? Or do I just basically just not, or do I take a chance that maybe I might go to prison? And that's very difficult at the individual level. Another very recent case was United States v. Spermetti that passed recently, and there was a state that passed a law that banned gender affirming operations and medical procedures for transgender youth. And what the Supreme Court said is this is not about sex, this is about age, and this is about health. So therefore, there's various levels of scrutiny that the Supreme Court looks at when addressing certain kind of state action. And there's a lower level scrutiny, there's a medium level scrutiny, and there's high scrutiny. The Supreme Court said, hey, this is clearly not about sex, so we don't even need to go into intermediate scrutiny. We're just going to decide that it has nothing to do with that, which clearly, in terms of the reasoning, it's not about agreeing or disagreeing with the outcome. I think there's a very legitimate argument to be made that you do want to protect children and that you do want to be careful with what is allowed for children or not. But it's really not the issue. The issue is that the Supreme Court decision is not legally well reasoned because it said that this is only about health and age, when in fact it clearly is about sex, and sex is a protected category under the Constitution. Another one that we talked about a little bit, it was Trump v. CASA. And in that case, and this is still ongoing, or this actually was decided, but it was kind of sidestepped. It was about whether the definition of birthright citizenship could be altered. And the Supreme Court did not really say yes or no, but they said district court judges, so the lower court judges, do not have the right to enact nationwide injunctions that would affect more than the specific parties at stake. So again, same kind of strategy from the Supreme Court. We're not really addressing the merits, but by addressing the procedure, we kind of are deciding the merits.
So we actually don't know what will happen. Probably in the upcoming year, the Supreme Court will consider whether we should change over 100 years of legal precedent and redefine what it means to be an American citizen, so that children born to undocumented immigrants in the United States would not be citizens. Children who were born to students, for example, studying to get their PhD in the United States would not be American citizens, right? Anybody who was in the United States for a temporary reason, who had a baby, even if their temporary reason lasted for a long time, would not actually, their children would not be entitled to American citizenship, which is something that has been assumed, again, since the 14th Amendment essentially was ratified in the 1860s.
And which is also shared by a lot of countries, because, for example, in France, if your children are born in France, they are French, and that just seems kind of a given, something that we don't really think about. So that's in play as well. And then the kind of last aspect that we wanted to touch about in this second category was something that is pending as well. You may have seen in the news in June, in particular in the Los Angeles area and Southern California area, there were ICE raids. They actually wear masks. They don't identify themselves, and they just go. And the thing that is really heartbreaking is that they go in places where it is well known that there are immigrants, especially Hispanic immigrants, who are looking for a job. So those might be, a place that is called the Home Depot, where people will go and workers just wait there to actually be working on construction. That's well known. They go there, they're raid. These are people who are looking for a job. They're not gang members. They're not breaking the law, but that's what they're doing. So there's been at the district court, a lower court that has said that the raids were illegal under the Fourth Amendment. Again, we will see what happens. We will see whether that escalates or not. It likely is going to be that it will, because Trump has filed an emergency petition to the Supreme Court seeking permission to actually be able to do that. The district court judge said it is impermissible for you to use as factors to arrest people, things such as, do you speak with a Spanish accent? Do you work in certain places? That is not permissible, because it really is, profiling at its best. But that's basically what was happening.
Finally, to kind of sum up, we wanted to talk about the ways that the Supreme Court is choosing cases differently and why that is fueling this expansion of judicial power and presidential power. Note that we're really not talking about congressional power here because Congress has been effectively silenced by the president. So Congress could step in and take greater action, but as of now, it has not been doing that. This is a slide that shows a new type of Supreme Court decision-making in selecting its discretionary docket. We call this the shadow docket. The Supreme Court doesn't like the term shadow docket, I don't think, because it sounds a little shadowy. So they prefer to refer to it as the emergency docket. And this type of this framework for hearing cases did not exist prior to the John Roberts Court. So when I worked at the Supreme Court, this was just not a way the Supreme Court granted review of cases. What the Supreme Court has been doing is essentially fast tracking certain cases, often cases brought to it by the government, in particular the Trump administration. So typically the court grants cases only after a long period of review in lower courts, and they often allow decisions to do what they call percolation throughout the lower courts. They prefer to have 3 or 4 different courts consider something before they make a ruling. Under the shadow docket, certain cases get fast-tracked and they get decided by the Supreme Court really quickly, including, for example, the case that we just showed you, Vasquez-Perdomo, where the Supreme Court is asking for emergency review, including CASA, the birthright citizenship case, where the Trump administration asked for emergency review. The Supreme Court is interfering with these, intervening and having its voice on these huge, important cases very, very quickly under the shadow docket. What does that do? Frequently, it ends up that decisions get made in favor of presidential power, expanding the power of the president. And it also expands the power of the Supreme Court because the lower court decisions lower courts aren't having a lot of time to go through the slow process of justice. And essentially the Supreme Court is just deciding what it thinks on very slim records and very quickly. That is the hallmark of the shadow docket. Finally, this I don't know if this happens to you. We're almost done, but I wanted to just note that another big change of this new Supreme Court, where Chief Justice John Roberts is perhaps trying to be an echo of Chief Justice John Marshall, is about the way the court interprets the Constitution. So there's basically 2 different camps. One camp believes that the Constitution is a living document, and we have to interpret it in accord with changing circumstances. I have to say, I think this makes a lot of sense because when the Constitution was ratified, there was no indoor plumbing, for example, right? No trains, no cars, right? We were a small, subsistence agrarian society, or at small mercantile, right? Commerce. The modern world did not exist. So it's very difficult. Women could not vote. People of color could not vote. The world was very different. So we have the living constitutionalists, and now we have people who would like to do what they call originalism. Originalism is where we only interpret the Constitution as the founders would have interpreted it in 1789, or sometimes as the 14th Amendment would have been interpreted as when it was ratified in the 1860s. I just want to, without going into details, I just want to note that that is a very retrograde way of analyzing the Constitution. It prevents us from expanding our understanding of rights. And I'd also just like to mention something that bothers me about this. The people who founded the Constitution, those founders, they were not conservative people. In fact, they were outlaws. They were rebels. They were radicals. They would have been hanged or shot if the British had won that war. So now we're sort of retrospectively imagining them as conservative, very narrow-minded people. But in fact, the evidence is to the contrary. They were open-minded and they were courageous and they were anti-monarchical, anti-authoritarian.
And I think that what's also really interesting for me, coming from an outside perspective, is that when I arrived in the United States, the originalism theory would make absolutely no sense for me, because I used to say, hey, in France, we are at our fifth republic. We have had so many constitutions that we don't really understand how you can be bound by that document or revering that document that was drafted 200, 300 years ago. Now, I think that that's one of the strengths of the United States, actually, to have that document, but I think it is a living document.
Finally, we just wanted to talk about the legitimacy of the court, which has been under fire in the United States. Usually the Supreme Court, if you put aside the legal details, which is a little bit strange to say in a room full of lawyers, but if we just put aside the legal details for a moment, usually the Supreme Court is pretty in tune with public opinion. It's not a radical institution. It's got its finger a little bit on the broad swings of public opinion. But in our country right now, public opinion is incredibly sharply divided. And what that means is that the court itself is fractured and reflects that very polarization. So in a way, the Supreme Court is a reflection of some very deeply troubling things that are going on in the country right now. They're kind of a human symbol of that. I also just want to acknowledge that in our country, I don't think we have, for example, processed the pandemic well. We have not processed the rise of AI well. We do not seem to be able to confront and process climate change well, or the rise of a class of people who have unimaginable wealth by any historical standard. And these huge trends are roiling the country. We don't have a way to even talk about these things, never mind process them. And I think to some extent, our current Supreme Court, with its retrograde views of originalism and its desire to lock things down, is a reaction to just a moment in historical time where many things are both outside of our control and in rapid flux. I just want to show our last slide. One of the most important things that the Supreme Court does ultimately is defend and sort of reinforce the rule of law. That is what we expect from the Supreme Court. But in many of the cases that they've decided recently, they've been about big questions about the rule of law, and the court has been silent about these things. The court gave presidential immunity to Donald Trump when he requested it, and it said nothing about his abhorrent actions on January 6th, nothing. It was silent. And we have to hear that silence in addition to hearing its words. And in the upcoming year, the court is hearing 2 different cases concerning a really vital statute for us, the Voting Rights Act, which is an effort, a longstanding effort passed by Congress in the 1960s to prevent the disenfranchisement of Black Americans and other people of color. And so one of the things that we need from the court is to reinforce the very rights that allow our democracy to continue to go, to continue to be a source of the values that many people associate with the United States. And I think that is very much in question right now.
Thank you all. We are all done with this presentation. And again, lots of food for thought. Unfortunately, not all very optimistic, but that is the situation that we're in right now.
Thank you, Professor Butler and Professor Porter. And I will hand the mic to Bang Choki. Floor is yours. 15 minutes, Bang.
Thank you, Magita. Thank you for the opportunity for inviting me to talk. It's good to meet other UW alum, Professor Porter and Professor Butler, Mbak Bibip, and also Mbak Gita. So yeah, I graduated in UW 2013 and 2024, just brief. So I want to talk about the judiciaries in context, especially regarding the governance, regulation, behaviors, and the rule of law. I'm not going to talk the case per se that has been happening in Indonesian judiciary. I believe Mbak Bibip, as a constitutional law scholars, will discuss some of the case studies. So I will take this opportunity to discuss about the expansions of disciplines in judicial research, or to expand the body of literature regarding the judicial independence, judicial integrity, and also judicial behaviors. So I think we can also take some of the stories, example cases that Professor Porter and Professor Butler have explained earlier, and we can we can suggest or we can identify that the judiciary is not solely legal institutions. It is a political institutions. So we can see from 2023, 2024, and until now, there's been recent cases that been upheld by the Supreme Court that expand basically president's authority and also hold decisions that in favor for presidents. So there are some research, mostly it's been grown in the US and Europe regarding the judicial behavior and judicial integrity. So I think there are some of the some rooms that we as Indonesian scholars can improve the body of literature on that topic. Next. Oh, I'm sorry, I have this. So here's the pictures we always as a as law students, as a legal scholars, as a lawyers, as a jurists, we always believe or we always hold this belief, right? That the judge, the judiciary should be impartial, should be, you know, should hold integrity and also should be independence. And it's also been explained, mentioned, ruled in other constitutions or specific or reference law. But as we have seen or heard from Professor Porter and Butler, they're not. In some cases, they're not impartial. In some cases, they're not independent. In some cases, especially in Indonesia, they are prone to corruption, right? So, so I think this is the fact that we need to understand more what the reason, how the mechanism of it, and hope. Oh, oh, yep. And is it part of the stuff? As soon, right after talking about corruption, and then the mic went off. Okay. Yeah. So I think this is the fact. This is the reality. This is the phenomenon that we've seen, read, heard every day. I think there's room for us as a law student, legal scholars, especially who, for those of you who are studying here at the Jentera, who are thought to be legal reformers, there are some rooms to reform the law. So by understanding the reason, the mechanism, the procedures, and the factors that influence the lack of independence, the lack of impartiality, the lack of integrity, so we can know what the best solutions, what the best proposal. So here's some key themes in the judicial behavior literature. There are some literature regarding the judicial independence, and also there's a body of literature as well regarding the judge motivations, behaviors. So judge basically a human. They respond to incentives, careers, etc. Judge reflects the opinions either from people, from peers, from public, from the leaderships, as Professor Porter already mentioned. There's also a body of research about the collegial court. I've just heard the presentations 2 weeks ago. It's very interesting in the U.S. when you had got that experience sitting in a bench with the same judge or work together with the same lawyers, you have the tendency to follow that decision. So it's really interesting. In Indonesia, we can also talk about, me and Babi Bib went to UI and also went to UDAP. If we sit together as a constitutional court, we might, fall into collegiality of a familiarity in deciding a case. So that's a room for research that have not been researched yet in Indonesia. I believe, where's Mbak Tita? Mbak Tita or Bang Davi knows the ethnicity matters a lot in our Indonesian Supreme Court, whether you're from Java, outside Java, whether you're from this university and that university, hierarchy of justice, and also the relations between executive and legislatures. So I'm just going to mention about the first two because I don't have much time, but I can give you the list of literature if you're interested to read. So first, regarding the judicial independence and institutions, we there's been a wide range of research shown that oh, okay. So okay, yeah. So 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 judiciary has been guaranteed for the judiciary has been guaranteed for its independence, as I said, in constitutions and law. But we all know there are some cases, there's some history where the executives or other political institutions try to capture the judiciary. So judicial decisions might not be independent, might not be reflected. Yeah. Check. I don't know. Check. Okay. So, oops, sorry. Okay. Yeah. So judicial independence, as I said, has been guaranteed by the Constitution and law, and the research also shows that when you have a judiciary that is independent, you tend to have a better economic freedom and growth. However, we know from the research, from the facts, from the cases, that the judges, have a bias, whether or have a can be influenced by political ideology or political institutions. Probably Professor Porter and Butler also could also mention about the current proportions of the U.S. Supreme Court judges, 6 to 3, right? And it matters in upholding decisions in favor for Donald Trump, for example. And Sunstein and Lee Epstein also already did a research for not only Supreme Court judges but also the elected judges across the U.S. and it shows the influence from the political institutions or political ideology in to judges. And regarding the Indonesian context, there has been quite a research on the judicial independence from Daniel Eslev. He is political scientist from UDAP, researching about the Indonesian judiciary 4 or 5 decades ago. Yeah, and he showed that the judiciary subordinated to executive power. Sebastian Pompe from Leiden also did that research after Sukarno and then Suharto regime. The judiciary also being co-opted by the executive power, and the recent research by Simon Budd showed that there's a hopeful result for after the reformasi. During the reformasi, judiciary show mixed performance, better court performance in terms of deciding many cases as before, but in terms of judicial quality, the arguments, the legal reasonings, it's still questionable, and also it continued problems of corruptions. And also inability to ensure the compliance with their decisions. So it's tricky for a court to get a legitimacy if their decisions cannot be enforced by or cannot be implemented by other institutions, whether it's by the losing parties, by the other branch of powers, etc. So there's a problems. One of the, as you can see, 3 of them are Western scholars or international scholars. So there are rooms for us as Indonesian scholars to get more data and do analysis more about the judicial independence. Next, regarding the rational choice and judicial motivation. So, in theory and empirically, the judges moved beyond ideological model by incorporating also in personal preference. So, personal preference matters a lot, such as job satisfaction, leisure, reputations, promotion, and salary into judges' utility functions, and also probably the probability of judges to being monitored by the internal supervisions body or by the judicial commissions. That's also take into account of judges' utility functions, and it suggests that judges are not purely legalists who decides case based on legal arguments, based on evidences, but also their behavior reflects a combinations of legal reasoning and also personal incentives surrounding them. So we have to accept that reality. And some research also shown that in Indonesian context, for example, Mas Herlambang from UGM, judiciary roles in political trials and human rights abuse often complicit with authoritarian regimes, so serving as a legitimation tools. So the judiciary seems to not want to take a bold decisions in terms of human rights abuse, etc. And Stefanus Hendrianto, he is also a PhD alum from UW, focused on constitutional court. He found that in the beginning of constitutional court, during the formative year, during the Professor Jimli Asidiki year, the constitutional court considered as a progressive, but later captured by politics and patronage networks. You have seen experience where when our Chief Justice of Constitutional Court, led by the uncle of current vice president, right? So that's one of the example, and I think there are also room for another research. This playbook, this pattern will occur probably later in the future. Dominic Nardi is also a political scientist. Judges, according to his research, is a strategic actor, balancing personal incentives and also career concern and pressure from political and bureaucratic elites. And one of his interesting findings is between 2003 to 2013 or 15, I forgot, he found that CSO, civil society organizations, NGO, is in influential actors for constitutional court. So he demonstrates how civil society can influence judicial behavior and constitutional interpretations in a transitional democracy. But now, can we still consider it as a transitional democracy? Probably Mbak Bibip can answer, or it's already authoritarian turn. So one of the most interesting finding or case study is during the Mahfud MD, as a Chief Justice of Constitutional Court. We know Mahfud MD grown in NU basis, and he went to UEE, Muhammadiyah basis. And one of the interesting case was brought by Muhammadiyah. We know Muhammadiyah focuses on educations and health and social welfare, but the case that Muhammadiyah filed is regarding the mining law. Undang-Undang Mineral, SKK Migas, correct me if I'm wrong, Mbak Bibip. And interestingly, 60% of Muhammadiyah claims, petitions, was accepted and used by the Constitutional Court to uphold the decision, to grant the petitioners or Muhammadiyah request. So it shows how the NGOs, the associations, the affiliations with the Constitutional Court justices quite matter. Next, in Indonesia, in my research, for example, in corruption cases, I interviewed 33 criminal justice actors, but I found that 3 judges, 5 prosecutors, and 7 lawyers argue that in corruption cases, punishment in terms of imprisonment still matters a lot. Because it reflects public anger at corruption as an extraordinary crime. They understand, they realize, they acknowledge presidential speech to focus on asset forfeiture. They understand asset forfeiture, monetary sanctions are the most efficient sanctions.
but they also bound by the public anger surrounding their jurisdictions. So one of the judges has that I interview has a son. He is currently a leader of the research center on the judicial independence, and and the judge told me that when I decided a corruption cases, only 2 years imprisonment, my son texted me because he knew that that name being scrutinized by Indonesian Corruption Watch or by other civil society organizations. And so the judge not only got mad, got public anger by the CSO and press, but also from his son. So that's one of the case where public anger could alter or influence judges' decisions. So takeaways, I think it's really important. It is a call to emphasize multidisciplinary approach in researching judicial system, whether you want to focus in judicial behavior, judicial impartiality, judicial independence. I think it's really important to integrate political science, law and economics, and also probably a sociological approach in judicial behaviors, because judiciary is not solely legal institutions, but political institutions, and law and politics are complementary. It's not opposing. By understanding the patterns better, we can find the solutions probably better. So that's my presentations. Thank you for the opportunity.
I don't have the microphone with me. Bivitri there.
Mas Amin has been very
Very helpful. Yeah, thank you.
Thank you.
Thank you. I will just start the presentation. Very happy to be here, by the way, with this, Choki said this is like the UDAP mafia. We are competing with the Berkeley mafia. They are economists in Indonesian Orde Baru many years ago. So I plan to present my presentation just in 15 minutes, but let's see if I can do that effectively. Again, thank you. And let me probably start with some striking differences and similarities. The striking difference, I would like to mention, I mean, although for Jentera students, probably this is not new, because, you know, in my class, legal reasoning, I actually ask my students to watch the movie on Ruth Bader Ginsburg. Anybody know anybody remembers the title? On the Basis of Sex. And also they learn quite a lot about the originalists and non-originalists also in my class, constitutional law. So, but let me probably start by informing those who are not in my class that there's the striking difference in the legal system. Law in Indonesia is mostly in the hands of the politicians, unfortunately. But probably this is similar to the French system, obviously, because we were colonized by the Dutch with the civil law system. And so Professor Porter and Professor Butler talked about the Supreme Court and started off with the Marbury Madison case to start talking about the Supreme Court authority on judicial review. But here I will present later on, I will start the situation with the political situation. However, there are, of course, striking similarities, which is, you know, very sad probably to all of us. And for me, myself, because I studied also in the US and I've been experiencing things even until last night. That's why we had the moment of silence. Thank you, Gita, as the moderator. that there are so many striking similarities. It's like it's the trend, unfortunately, in the world at this moment with the authoritarian regimes. So the similarities, for example, is that, for example, I just mentioned the keywords: expanding presidential power legally, quote unquote, through court, through the law and executive orders, because we can see that in the last at least 10 years, so not only in the President Prabowo administration, but also in the Joko Widodo administration, we can see how many executive orders in Indonesian system, which means the peraturan pemerintah, government regulation, and peraturan presiden or presidential regulations, that basically gives so much leeway, so much discretion to the government, especially in expanding the economic power of the oligarchs. And then the other similarity or similar keyword is the contracting constitutional rights. I learned a lot about what's going on in the Supreme Court, U.S. Supreme Court cases. But the similarity, of course, is the use of legal arguments in those decisions. But in the very in the way that we can always, debate. So with that, now again, hukum, law in the Indonesian context. So I always mention that probably we have kind of the phenomenon of loss in translation, because for us, hukum is taken from the Arabic word hukum, yeah, means justice, basically. But then we actually adopt the whole legal system from the Dutch. Again, this is the colonization theories and all that. But then we have this positivistic point of view in law faculties in Indonesia generally, I must say, probably except Jentera School of Law. So that Indonesian lawyers are so used to talk about law as regulations, and basically regulations, not even court decisions. Only recently that the younger people like Choki, like myself, Binjat Kadafi, and Gita Putri Damayana always remind people that, look, we have to talk also about court decisions, not only laws and regulations made by the politicians. But we also mostly talk about lawmaking institutions and law enforcement agency, obviously. The next slide, I would like to briefly talk about, just to give the framework of our discussion, authoritarianism and the constitutional law. I would probably start off with the arguments of the competitive authoritarianism that I believe that we are having at this moment in Indonesia. So there has been debate whether Indonesia is still democratic or not, but frankly speaking, since a couple of months ago, I already stated publicly that we are not a democratic country anymore. We can, use different scholarly terms on this, but let me probably put on our table the argument from Levitsky and Wei about competitive authoritarianism, whereas we might think that we still have democracy in a way that we still have the working, quote unquote, House of Representatives. We still have obviously working presidential institution and all that. But the question is really, for whom are they working? Are they working for us, the people, in the democratic term, or for just the elite? So, but in spite of that, law has obviously legitimacy to control. So here we can use this is what I've been researching about, autocratic legalism, the term by Javier Corrales and then also Kim Lane Chappelle. And just quickly to review quickly that in my opinion, we have been actually looking at the working of autocratic legalism in Indonesia. I started to write this since 5 years ago, and but my article is like expanding year by year like crazy. I started with the declining anti-corruption commission, and then declining obviously House of Representatives. But then it expanded to court capture and then the weakening of the civil society. So all this phenomenon I read as the symptoms of the autocratic legalism. So if we look again at the literature, if we look what happened in Venezuela, Javier Corrales reviewed that very thoroughly, or what happened in Hungary. Unfortunately, we might see, hopefully not though, but we might see very soon the amendment to the constitution. That's the playbook. And let me remind you that in the, how do you call it, in the vision of the political Gerindra as political party, it's written that they want to go back to the old constitution of 1945. So, but that we can discuss later on. I would like to now briefly talk about constitutional court in recent months. I happen to write the story from Indonesia with Stefanus Hendrianto for the ICONEC Global Review of Constitutional Law. So I have the details on the recent cases because that's what we do basically every year. We submit cases from Indonesian Constitutional Court for the Global Review of Constitutional Law. But for this year's review, Hendrianto and I highlight the fact that we call the Constitutional Court in uncharted water after the controversial decisions on the Gibran case, October 2023. So since then, the court has tried to rebuild its reputation and regain the trust of the constitutional stakeholders. While the court never corrected the controversial decisions, the Gibran case, despite some opportunities presented, in our opinion, the court has tried to compensate for its mistake by issuing some decisions that can be seen as quote-unquote progressive. While those decisions were positive for democracy and the rule of law, the court, though, was inconsistent with its reasoning. So that's also what's, as scholars, Hendrianto and I use the word, uncharted water. I mean, we are not sure whether this is a good thing or bad thing because yes, they are progressive, but can they be sustainable or not? Because the argument has not been consistent. So, for example, when it comes to applying the so-called open legal policy, I'm sure by now many Indonesians already are already familiar with the words. The court didn't do a compelling argument on why open legal policy could be invoked for one, but not to another. I don't want to. Probably I should though. Probably I should just mention at least two. I should, because I'm looking at my timer and I still have 4 minutes. So I should mention probably just two court decisions that so that Professor Porter and Professor Butler will be can join the conversation. One very important decision is the one that basically nullify the presidential threshold. That's basically now we don't have the presidential threshold in Indonesia means, which is unusual in globally, but in Indonesia it means that for a party or coalition of party to be able to put names, candidates of president, they have to have minimum 20% of votes. we don't have it anymore because of the Constitutional Court decision. And then the second case I would mention, also important in terms of the politics, is to divide between local elections and the national level election. That's also very recent. But now I would say that despite those very interesting developments, there are many more, but we can talk about that probably in the question and answer session. We have real threats, even to the Constitutional Court. First of all, please remember that 2 justices will be retired very soon, and one is already basically has a replacement appointed by the House of Representatives in an unusual way. Meaning there were, when we probably assume that there was a fit and proper test procedure, there wasn't. It was like a speech from one candidate only. So I don't know if we can call him candidate. But anyway, he is already selected by the House of Representatives to replace Pak Arif Hidayat, Justice Arif Hidayat, who has been also in the progressive camp, if you remember, together with Justice Saldi Isra and others. And then there will be another vacancy. That will be the uncle of our vice president. But then he will be replaced by the Supreme Court. So we have 3 justices from the Supreme Court, 3 justices appointed by the House of Representatives, and 3 appointed by the president. And then we probably have to face very soon the change on Constitutional Court law. It's been on their table since last year, actually. And it will give the authority to the appointing institutions to basically evaluate the justices, which is against the principle of the independence of the judiciary. They can evaluate the justices and they can replace them whenever they want. That's pretty crazy. So that's one. And then secondly, the government or lawmakers' refusal to comply with the Constitutional Court decision. And that's, we can see lately that the House of Representatives and political parties already declared that they disagree with the Constitutional Court decision to divide local election and national level election, which in the rule of law perspective, obviously, is something that a House of Representatives cannot do, political parties cannot do. And then we also see the continuing usage of military power, very dangerous to the rule of law, obviously, and the police to control the society. And then the continuing abusive lawmaking and law enforcement. So Professor Butler and Professor Porter, we have been going to the Constitutional Court very often lately, just to tell the Constitutional Court that the lawmaking processes has been very very abusive lately. Because, for example, one law can be processed in just 3 days. That's the state-owned company law, for example. Or the law on the military was discussed in 9 days, for example. I'm not debating the number of days, but then we have been debating about the participatory lawmaking process, which is lacking in the recent lawmaking processes. So I guess I would end my presentation here, so we have room for discussion. I'm giving back the microphone, probably literally, to Gita. Thank you. Cukup nggak tapi?
Thank you for all the presenters and by this. And this time I will open the first Q&A session. And for 3 person, and please say your name and give us your question, just one question without sharing too much of everything, like you're sharing your heart out because of everything. Just limit yourself with one question. And please tell us which of the presenter you address the question to or to all the panels. Silakan penanya pertama. 1. Saya tandai dulu 1, 2, 3. 1, 2, 3. First one, the lady with wearing the black shirt. And second.
Check.
Second. 2. Second person with the black shirt. Okay. Second and the third. And I really love that the questions are all with black shirt. Yeah. Okay. Yeah. Okay, your third question. Thank you, Priyanka. Go ahead. Mbak, silakan.
Good afternoon, Bang Choki, Mbak Professor Butler, Professor Porter, and Mbak Gita. I'm Stephanie Gloria, one of the students of Bang Choki's in Faculty of Law, Universitas Indonesia. I'm very interested discussion whether the Constitution is a living instrument or not. In the scenario where we all have common understanding it is a living instrument, then to whom actually should we give powers and responsibility to do the interpretation? And if the answers is to the judges, then actually what are the parameters should they use? Is it the public opinion, which is also prone to the making of a populist decision, or is it to executive or legislative request, which is also prone to corruption, or is it to some customary law side, or even towards their own opinions, which are also acknowledged here that they're self-biased and usually have proven to be not well elaborating in their own decisions. Thank you.
Thank you. Maybe you want us to, I think we better collect the question first. Yeah. Second.
Thank you for all. Pardon me for my broken English. So good. But yeah, I recently these days I just attend some seminars, including this one, and I just I'm feeling down more and more to listen for the sad stories about how the law in Indonesia and today it's even not only Indonesia but even in the US, which is the country that I can say that we Indonesia is are look up for the law and everything mostly. So it's kind of we have similar situation about how the politics just how to say give impacts in the law, or even law is used by the politician for their goals, and it's said and maybe I, I just want to say how I just want to express my feeling. I don't have any question. I just thinking, do we have hope? Because once we had, like in Indonesia, it's like 10 or 15 years ago, we were like in a hype situation. We were going to a brighter days, and yeah, somehow we had that time. But today we are like in cleaning, and maybe in US, or I don't know, in the entire world, I don't know. But do we have hope actually? Or do we have to be politicians first just to have a better law system? So I don't know. Maybe maybe I don't need to be lawyer. I just shift my goal just to be politician first. I don't know, but thank you for the opportunity.
Thank you. And I think we could use that question as our closing statement for each of the presenters, like finding hopes and can we still be able to become lawyers? And Priyanka?
Hi. Hello. Is this working? Okay. Hi. My name is Priyanka. I'm from Jentera as well. This question is, I guess, more reflective than Mbak Nur, but it kind of correlates as well because if we look back at the situation of our democracy right now, as a Gojek driver was just run over by what was it, a Brimob yesterday, and I was wondering, yes, is there hope? But also what can the law do about it, whether that be idealistic or realistic? And we can look at it from an Indonesian or an American perspective. I was just wondering what law is supposed to be and what we could be to fix the current situation right now. Thank you.
Thank you. Maybe each of you could answer the question. Thank you.
And we can do
Is
it.
this
in
so
tandem
we're
if you
taking, we're
want.
doing the first question
Yeah.
first.
I think, yes, or we can just do however we want to. So the first person.
I'll take a stab at the first question since
Yeah.
I'm the one who dragged you through originalism
Yes.
in the opening talk. And I guess before I answer, I just want to note I have many problems with originalism. I find it intellectually empty. But one of the reasons that I find it empty is that it's actually just a fad. It's a trend.
Yes.
Originalism is not original, right? Now bell-bottom jeans are popular. Now skinny jeans are popular. And originalism is actually just the latest iteration of what has become popular and current in constitutional interpretation, which is that to say that originalism itself is it's an example of a living constitution, right? Originalism didn't used to exist 70 years ago. We didn't think about the Constitution that way. Now we do because it's popular now. It's just like Bruno Mars versus Taylor Swift. And in that sense, it is itself a demonstration, an example, a proof that our Constitution is living and does change over time.
Yeah.
But that doesn't answer your deeper question, which I took to be one of metaphysical chaos. Well, how do we make decisions? Which is what the originalists say. We need to have guardrails. Otherwise, we don't know. And I'll give you a different analogy, how we eat, how to eat a healthy diet. Unfortunately, the answer is we need to be moderate and eat a wide variety of things and avoid poisons. And our constitutional interpretation, and I don't know about you, but I find that the suggestion for how to eat a healthy life and exercise in a moderate way, these things are boring and they're hard and they mean less cake. And constitutional interpretation is the same. We can't rely solely on precedent, but without respect for precedent, where are we? We can't look solely at what the founders thought in the 1780s because they didn't have telephones and there were no women involved, no people of color involved. We can't at the same time defer solely to Congress. In fact, we need to have a balanced constitutional diet. And doing that is not glamorous. It's fairly dull. And just like with eating, it involves a significant amount of restraint, of institutional restraint. We can't eat all the cake that we want. And so I don't think there's a single answer, but the answer is that all of these tools in moderation can help us slowly over time do the best thing that we can do. And just as with eating, I don't think any extreme solution is likely to be sustainable or make us constitutionally and democratically happy.
Yeah.
That's my view.
Yeah. And I think to very quickly, because I think Professor Porter has said most of what is helpful to say here, but you asked, hey, where do we look? Public opinion, but there are issues, executive, but there are issues, the judge's own opinions, but obviously that's going to be subjective. I think to go back to what you were saying earlier, I think that we need to also understand that the law is not objective, right? We have this idea, or it's been ingrained in us, that somehow the law is this neutral, objective tool. It's not. It's a human instrument. So it's going to be flawed no matter what. There are no such things as transparent rules. The law has been created to advance the majority power. And we can see that very easily when we actually look at what happened even in employment law, when we look at what happened in sexism or work discrimination, when we looked at sexual assault and how it used to be in the United States, in any Western place, that if you wore short skirts and you were sexually assaulted, well, it kind of was your fault, right? Now we cannot consider that anymore. So the law is something that reflects the norms of where we're at and human beings. And it is a combination of all of those things that you talked about. But as Professor Porter said, if we combined all of those things, we can actually get to some sort of wisdom. The issue is when we are not able to combine all of those things and we're not looking at precedents and we're not listening to public opinions and we don't think about the law as what has been decided in the past and how can we logically apply it. I think that that's when, if we do too much of one, then we're going to run into issues. It's not perfect, like democracy still is the best system that we have.
To develop his argument. Okay. Yeah, probably I believe you guys probably want to listen more to what Professor Porter and would say on this. But just I would like to give you my perspective from the Indonesian point of view about the living constitution. Parameter for judges. Of course, the normative way to respond to that is that there is no parameter for judges. This is the biggest challenge for me to to teach the legal reasoning class, because there should not be any parameter for judges. It's really about their legal reasoning, which they will be held accountable for, that we should read in their pertimbangan hukum, right? In our model of decision making in Indonesia. But the problem is then, is there any right answer to a case or not? Our assumption should be that they are experts. They can be justices because they're experts, because they have experience. So there should be, let me reiterate that, methodologies and probably interpretation methods, whether it's like sociological jurisprudence or realism or whatever they want to use. But the problem again is that there is a fact that for most Indonesian scholars who are not, I hope, in this room, we are so used to the positivism point of view. So justices here are mostly seen as, we call it corong undang-undang, as the speakers for the wordings in the law. So as if they cannot interpret, freely what the law says. So I would respond to this by saying that despite I can sense your frustration, just as anybody else in this room, I would say probably we can have hope in the, legal education. If we can really change the legal education, and that's why we have Jentera, and that's why we have scholars like Choki in a number of universities. That's why we have, the Association of Socio-Legal Scholars, where Mbak Tita from Jentera is also a leading person in that association, that we want to bring new thoughts, new ways of thinking in the future Indonesian lawyers. So probably it's okay if we give up our hopes in the in the older generation of lawyers, but I can still see hopes if we change, if we can really reformers, I have hopes that in the future we can have more vibrant living constitution that can really read into new trends and developments in the society. So yeah, that's my answer also for Nur, and probably a little bit for Priyanka. Thank you.
Thank you. I just want to reiterate what Professor Porter and Professor Butler already explained, that I think we need to be moderate. Moderate means that we are not imposing some policies to the one of the extreme poles. But in doing so, we have to understand it first. I think that's what's my call in these presentations. My call is to understand the judicial system, the Indonesian judiciary better, not only from the legal law perspective that is idealistic, sometimes naive, but also there are some nuances and contexts that we need to dig deeper. And as I have shown, many scholars who did research about Indonesian judiciary, they brought multidisciplinary approach and perspectives, whereas I haven't seen quite enough, large numbers of scholars from political scientists, economists, sociologists, or anthropologists in Indonesia to look at the Indonesian judicial system, Indonesian judiciary. So, for example, economists can help us to understand how the rules, how the regulations change the incentives within the judicial system and the personnels, and how the incentives works or interplay. So, for example, there's a judicial commissions, there's an internal supervisory board that's changed the incentive or disincentive. Because if you have bad reasoning, you're subject to scrutiny, right? Does this disincentive change the way judge make a judicial reasoning or not? I think that's really interesting to look at. And political scientists like Daniel Eslev, Dominic Tardy could also look how power works and how power consolidates, how power try to co-opt the judicial system, and what's the process, what's the mechanism, who's the actors. I think one of the most interesting thing, I don't know, it's a hunch, it's not a hypothesis yet, but Bibip mentioned about the military power, right? We know under this regime, he is from military, he has appointed so many military general or retired in every positions, and that's very vivid, that's very explicit. But there's one implicit organ that we can look at, Taruna Nusantara. I don't know how this, Taruna Nusantara for it's like a Midwest academy. It's not a military institution per se, but it's a high school degree, but it's established by the military, and they have so many alum in every sectors. So I was just wondering how many judicial policy, how many judicial reviews will be petitioned by these organizations or by this alumni, and it could also change, and I think that's one interesting, the political scientist. Sociologists can also help us understand how the institutions, how the judicial organizations influence the way that the judges work right now. Anthropologists can also look at how the culture influence how the judges behave. There's a hunch, correct me if I'm wrong, Bang Dapi, judges from certain ethnicity, judges from certain region, judges from certain universities have a different legal thoughts, school of thoughts, the way they reasoning, the way that they're organized and do the work. And I think that's really important. The judges who play better tennis could get better positions, for example. That's the culture in Indonesian Supreme Court, in the judicial system, and that's very interesting. Are you gonna appoint higher ranked judges not based on their judicial reasoning, but based on how good they play tennis? That's a room for really scientific finding and scientific research. And anthropologists, legal scholars can work together to provide that type of findings. And if we already understand from the multi perspective we can then have, as Professor Butler say, combining all the tools, not only imposing, not only creating, policy, legal policy, but also legal policy that take into account how the incentive works, how the powers work, who's the organizations, who has the bigger power, and also the culture itself. And not to mention about AI as well. I think that's a really, room for research, room for expanding our literature in judiciary. One last thing, Bargita. There's one interesting pleidoy defense by Tom Lembong. I think that's a very interesting case. Tom Lembong, in his defense, he said that according to AI, held that I'm innocent, right? But then the judges, decided that Tom Lembong, convicted Tom Lembong, right? He found guilty. A week later, President gave clemency. Is that correct? Yeah, clemency for Tom Lembong. But I mean that's a room for research. If the AI, right? It's a questions whether the judicial system, Indonesian judiciary, have the legitimacy or not, and that's a room for improvement. We can scrutinize many court decisions that we think do not have a good judicial reasoning, and then compare it to AI, and then we can, have new findings about it.
I think if based on what you said, that we were starting with Priyanka's question second and then finishing with, okay. Okay, all right. So Priyanka's question was, if we look back at democracy, what happened yesterday, for example, is there any hope, and what can the law do about it? So I'll have you go for it, and then we'll go down.
First, I just want to acknowledge at the outset that positive law can't answer all questions, and that there is a time when the answer lies in the streets. At the same time, at least in the United States, the law can provide some relief, and our system is a little bit different. And I think one of the things that is irritating and inconvenient for many people who are trying to solve legal problems in the United States, but also helpful and a bulwark against the erosion of democracy, is that we have a dual federal state system. And many people actually in the United States now are turning to state politics and state courts, and their states are a source of resistance, and states as have a quasi sovereign place in the United States. What does that mean? It means our law is messy and inefficient and chaotic, and who controls our elections? States, for example. So I realize that you don't have a state system in Indonesia, but I think all politics are local politics at some level, and looking for ensuring or guarding the rule of law in smaller settings can actually be a positive step toward greater norms of democracy and the rule of law on a national level. I guess, but that's not a perfect answer. I just want to acknowledge that. And one of the problems we're having in the United States right now is too many. There are too many things happening. And so it's difficult as a citizen, as a lawyer, to fight those things. And it's even difficult to pay attention to all of those things. There are so many things that it's seductive to just turn it off and hide and not pay attention. And I think that numbness is perhaps our greatest risk right now. So can the law solve the problems? Not necessarily. Do we have to try to use the law to solve problems? Yes, because if we don't exercise those law muscles, they will atrophy.
Yeah. I'm in complete agreement with that. And this reminds me, and I think I've said this to some of you who were in my class, but when we, at the University of Washington, we've had a lot of speakers this year coming, and they have been speaking about the attacks on democracy and what's going on. And each time when I would go and listen, I would come out even more depressed. I just thought, I don't even want to attend those things anymore because it's just like breaking my heart. But then I attended one of them, and there was this man who was an American diplomat and a politic, and who now is actually serving at various universities, and his name is Harold Coe. And Harold Coe, I thought, oh, this is going to be again one of those kind of like, woe is me and things are just terrible right now. He served under President Clinton. He served as a legal advisor in the State Department under Obama. He was born in Massachusetts, but he says, and here I just kind of pulled up this because I think it's important, his parents grew up in Korea under Japanese rule. And he said that his parents grew up under Japanese colonial rule, forbidden to speak Korean or even to use their Korean name. So he has a very strong feeling about democracy, about the rights of immigrants, about what's happening. And he said to us, academics, he said, yeah, what's happening right now is not great. You have to stop complaining. You have to stop whining. You have to stop writing stuff that no one reads and no one cares about. And what you have to do is you have to file lawsuits. And you have to keep on filing lawsuits. You have to keep on exposing things. You have to do what Bivitri has been doing constantly. She did not sleep much last night, if at all. She did a movie. This is what you have to do, and this is the hope for lawyers. So that's what the law, I think, can do about it.
Oops, don't worry, it's already empty. Okay, so in line with the two professors, that I agree that, and this is the community of lawyers, so I'm happy that I can talk about this more openly, that because in many other discussions, I always say this is not the airport, so I can use this word, that I put the bomb in the room, which is that it's a system failure that we have in Indonesia. But I would again say that actually the rule of law is the answer. So I agree with the two professors again. We lawyers should, I think, go into politics like Obama. I mean, because in Indonesia, we are not used to the idea of lawyers going into politics. Politics is unfortunately so quote unquote dirty, according to many Indonesians. So lawyers just, want to be rich or they go into the streets. But very rarely that we go into political parties and House of Representatives and all that. That's one. And we defend our rule of law. I agree with you. By going more into the courts. So the problem for us is, I think, first of all, we depend too much on the undang-undang made by the politicians. I mean, our legal discourse is limited to, law schools, legal scholars only. So that's why I think the rule of law has not been really embedded in the society. So probably it's about time for us to bring more the rule of law arguments into the politics. This is, I think, for us to change the new generation of lawyers or law graduates. Yeah. So the question is then really, I still have hopes. I do very much. Otherwise, I wouldn't be here. The problem is, the question is now for all of us is that, are we ready as lawyers, law graduates, to defend our constitution by going to the courts and probably at some point to the streets when the constitution is probably changed, probably very soon. So I think the safeguard for our democracy is really the rule of law, and we legal community and also non-legal community have really to defend at least the legal framework, the constitutional values that we currently have. Thank you, Gita.
I don't have a hope in legal terms like what Professor Butler and Bivitri mentioned, but this I'm millennials and probably some of you are Gen Z. My hope is can we do things differently and hope for different result? And I think there are resources, there are opportunities, changes for us to do differently, to utilize legal institutions differently. If
yeah, that's my hope. Just utilize it, just try it, just file as many as civil lawsuit. With the current resources, you can invite video Zoom with professors from international communities to give their perspective, doctrines that they know. Hopefully, it will give a change. So I have a hope that we can do differently, and I hope it will create a different result, whether it's in consolidating demonstration tactics, filing civil lawsuits, combining international scholars and multidisciplinary scholars, and also using your social media for spreading news. That's all.
As we bring this compelling topic discussion to a close, I want to extend my sincere gratitude to our distinguished panelists, Professor Butler, Professor Porter from the University of Washington School of Law, and as well as our Indonesian counterparts, Bivitri Susanti and Choki Ramadan. Please have a round of applause for our speakers. Your insights have been invaluable. We've explored the critical tension, and this is me trying to summarize the discussion. We explored the critical tension at the heart of a modern democracy, the judicialization of politics, and our speakers have expertly guided us through how our courts, from the U.S. Supreme Court to Indonesian own Constitutional Court and the Supreme Court, are no longer just passive arbiters but central political actor. This dual role as both guardians of constitutional principles and participants in political contestation is a universal challenge for the rule of law. This brings me to a crucial point, Choki Ramadan, a sentiment that resonates deeply with us here at Jentera. He highlighted that much of the foundational knowledge of Indonesian law has historically been documented, analyzed by foreign scholars. While this is not a criticism and it is a call to action. It reminds us that we as Indonesians must take ownership of our own legal scholarship to study and create our own knowledge from our unique content. This is precisely the spirit of what we do at Indonesia Jentera School of Law, a mission that is beautifully represented by the work of Bivitri Susanti, and our allies here, including Choki Ramadan at Universitas Indonesia, as well as our international partners, Professor Butler, Professor Porter from the University of Washington. And before we conclude, I would like to invite the head of Indonesia Jentera School of Law, Dr. Arya Suyudi, to deliver his closing remarks for this public discussions and the whole summer course. Bang Arya, the floor is yours, or the podium is yours.
Warahmatullahi wabarakatuh. Let me look at my notes. Distinguished speakers, Professor Mireille Butler and Professor Elizabeth Porter from University of Washington School of Law, our esteemed Indonesian lecturers, Mbak Bibip dan Bang Choki Ramadan, respected colleagues, students, guests, welcome to the Jentera Law School. I was asked to give closing remarks for this. Before we continue, I would like to ask for a moment of silence. Let's take a moment to pause to remember and pray for our brother that become the victims during the protest yesterday. Let's use this time to stand our strength and hope to the victims and their families. Let's remember the humanity at heart of our movement and commit to a future where change doesn't come at the expense of anyone's safety. Let's pray that their soul will be rest in peace, and let's pray for a better, safe, and democratic Indonesia. Let's start. Thank you. Okay, ladies and gentlemen, the completion of this lecture marks the end of 2 weeks long of an international course of intensive international short course on legal research and American legal system. This is the maiden collaborative project between Indonesia Jentera School of Law and University of Washington School of Law. We are very happy and proud that we are able to host these two respected scholars from University of Washington giving lecture to us for 2 weeks long. And we are very honored to have this final discussion, taking the issue on the judiciary. I think this is very important because the judiciary is the branch of the government that serves as balancing power to ensure that the other branches doesn't abuse their powers. We all know that Alexander Hamilton, one of the founding fathers of the United States, said that in principle, judiciary is the weakest branch of the government. They lack of the power of what the other branches of government have, namely the power of swords and power of purse. It has no influence over either swords or the purse, no direction either of the strength of or of the wealth of the society, and can take no action, resolution, whatever. It may truly be said that have neither force or will, but merely judgment. That is why the discussion this morning is very important, to see to what extent it has performed their role, and to what extent challenge that they are facing, and to reflect it to the context of Indonesia. Now, the discussion has been very fruitful. I think there are three key takeaways. First, institutional design and ethics, that transparent judicial selection, robust ethical standard, and credible conflict of interest safeguard, build, not weaken judicial authority. Second, quality of reasoning and public trust, clear, well-grounded decisions, strengthen constitutional culture, and help public to understand, not just accept outcomes. Third, a supportive ecosystem. University, civil society, media, and policymaker must collaborate to keep the courts independent and accountable. So we uphold the rule of law, not rule by law. Finally, let's carry this forward. A joint research, policy brief, share teaching materials, and practice online-oriented clinic. The goal is simple and urgent. Institutions that are principled, transparent, and resilient in the face of political contestation. Our gratitude to all speakers, participants, partners, donors, and technical team who made this hybrid event possible. Thank you for your engagement and commitment. We look forward to a continuing collaboration to strengthen judicial integrity and constitutional democracy in Indonesia and beyond. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
And Bang Arya, please don't go too far. On behalf of the Indonesia Jentera School of Law and Siregar Setiawan Marlon Partnership, please join us to give a big round of applause again to our speakers, and for Bang Arya to give the present for our speakers here. But not to me and Bibi, because we're like from the house. Orang dalam, yes. So Bang Choki would be first, and then Professor Butler and Professor Porter. And now Professor Butler and Porter. Yeah. And now from our partner, please. There's still gifts. Oh, so Professor, oh yeah.
Just great for my computer.